So, there is something happening right now, as we speak, that is so controversial, it is making people's heads spin, particularly the record labels. A long time ago, so long in fact that Jimmy Carter was just elected president, a law was passed. It was called the Copyright Act of 1976. However, the law didn't actually come into effect until January of 1978. Why do we care? We care because this law said that an author can terminate the rights they granted after 35 years. And if you're good at math, you know that 35 years from the date the law came into effect is January 1, 2013. What does this all mean? It means that there's a good possibility that an artist who recorded a song for a record label 35 years ago, whose recording has until now been owned by the record label, can now tell the record label that they get to take their recording back and own it. Well, it's not quite as easy as that, but let's take a look at the law. The law says that after 35 years, an author can terminate the rights they granted, which essentially means that they can reclaim their ownership, provided that it is not a work for hire. A work for hire means that whatever you created is owned by the person or company that you specifically created it for. Now stay with me because this is where it gets tricky. In order for something to be a work for hire, it must meet two very strict requirements. First, it must be in writing that your services are a work for hire. Now, most record deals do say this. However, there is a second requirement, and this is where it gets sticky. The second requirement says that in order for something to be a work for hire, it must fall within one of 9 categories. If it does not, then it cannot be a work for hire, even if the record contract says that it is. And remember, if it is not a work for hire, then the author can terminate the rights they granted and reclaim their ownership of the recording after 35 years. So, what are these 9 categories anyway? Oh, here they are. I see audio-visual works and motion pictures, instructional texts, test answers, but something is missing. There is no category for audio recordings, and audio recordings are records. Now, who was paying attention? Did you catch that? Did you notice that there is a category for compilations and a category for collective works? Let's look again. Yup, there they are, contributions to a collective work and compilations. Well, these are the categories that the record labels will most likely claim that the recording falls under in order for it to be a work for hire. But the artists will argue that if Congress intended to include records, then why didn't they just include audio recordings as a 10th category? For instance, they have audio-visual works and motion pictures. Why didn't they add audio recordings and records as well? And even if a recording did fall under the category of compilations, then this would most likely only apply to the full compilation album itself, not each individual recording. So the work for hire here would be the album entitled Pretty Baby that contains a compilation of Blondie recordings, but it would not apply to the individual recordings themselves, such as Heart of Glass, One Way or Another, Hanging on the Telephone. There is one other way that something can be a work for hire. This is if the work is prepared by an employee within the scope of their employment. The record labels will most likely assert that the recording artist is an employee of the label, but they may have a hard time with this position since the test to determine whether or not you are an employee is very stringent. Well, now you understand the serious dilemma that the record labels have. Even though the record contract with the artist may say that the recording is a work for hire, the artist has a strong argument that it is not because it does not fall into any of the 9 required categories. And remember, if the recording is not a work for hire, then the author can terminate the rights they granted and reclaim their ownership of the recording after 35 years. So, if the artist succeeds in this argument, then they're home free, right? Not so fast. If you were listening closely, there's one last very important thing. Who did we say can reclaim the copyright? We said it is the author. But wait a minute. Who is the author of the recording? Who created it? Was it the artist? Was it the record producer? Was it the engineer? And by the way, if this applies to musical recordings, what else could authors potentially reclaim? Well, these are all really good questions. And now you see why 2013 is going to be a very interesting year. Oh, and one last thing.
Disclaimer. This audiovisual production was created by Berkeley Reinhold at 10 a.m. on a Saturday and not during the scope of her employment. 100% of all right, title and interest herein shall be solely owned and controlled by Berkeley. It shall not be deemed a work for hire.
Get it?